Good morning, Mr. Colbert.
Morning, Your Honor. Please the court, Rick Colbert. I'm here on behalf of the defendants and appellants, and I'll just generally refer to Mr. Howerton. There's a corporate defendant as well, but
sure.
And I'd like to reserve 3 minutes of my time.
3 minutes, yes, sir.
Mark Pirtle and John Howerton were longtime partners in the automotive business. And in 2014, Mr. Pirtle agreed to sell to Mr. Howerton his interest in a Honda dealership that they shared. It was 490 shares of stock. They entered into a stock purchase agreement, and these agreements are in the record. I don't know who drafted them. They clearly weren't lawyer drafted, but there's a
they're not pieces of art.
No, they're not. Sure. There's a July 2nd, 2014 stock purchase agreement. The purchase price in the original agreement for the shares was $1 million, and there's no dispute that that was paid. There's also dated July 2nd, 2014, a handwritten agreement which has 2 sentences in it. The first sentence is intended to be a release of debts from a past dealership that the 2 gentlemen were involved in together in Shelbyville, Tennessee. And the second sentence says that if Mr. Pirtle dies, Mr. Howerton will honor the agreement, all agreements for 1 year, and then all debts are fulfilled. And then there was an addendum that was signed by the parties shortly after these, the agreement and the handwritten agreement. And the addendum called for Mr. Howerton to pay Mr. Pirtle an additional $8,000 a month for 96 months and to make 2 auto lease or purchase payments up to a maximum of $1,500 a month for 96 months. Mr. Pirtle died in October of 2022, which was 99 months after these agreements were executed. There's no evidence in the record of there ever having been any dispute between the parties over the 96-month life of these agreements. But the administrator of Mr. Pirtle's estate, his son, couldn't find records of all the payments over that 96-month period, so he filed this lawsuit. The estate sought damages of $592,000 for the $8,000 payments that allegedly were not made. They also sought another $132,000 in damages for I'll call them the vehicle payments, and they sought attorney's fees under a hold harmless and indemnity provision in the original agreement. The trial court granted partial summary judgment on the $8,000 payment claim and the attorney's fee claim, although it was later when the amount was established. And then there was a trial of the vehicle payment claim, and at the close of the plaintiff's proof, the trial court directed a verdict for Mr. Howerton because the estate had not proved that there were any car payments to be made that Mr. Howerton had not made. We appealed the partial summary judgment. The estate has, they don't call it cross appeal, but the estate has appealed the directed verdict at trial.
On the car payments, it does indicate that the presumption is that if a car is provided, or actually 2, that the dealership will pay up to $1,500 a month for whatever the lease payment is or what have you.
Correct.
But is there any proof that the expense was incurred by the decedent, Mr. Pirtle?
No, and that was the basis for the directed verdict at trial is the absence of any proof that Mr. Pirtle or his wife, it was a car for him and a car for his wife, and there was no proof at trial that Mr. Pirtle had a car payment, lease payment, purchase payment for Mr. Howerton to make that Mr. Howerton didn't make. There was proof of some payments Mr. Howerton did make, but there was no proof of other payments due and owing on cars that Mr. Howerton failed to make, and that was the basis for the directed verdict at trial. Gotcha. On the $8,000 payment claim, we've in our brief, we've recited a host of reasons why we believe summary judgment was incorrect. in that case. I want to focus on two of those, and I know there's an argument on the other side. We raised consideration as an issue, the absence of proof of consideration, and there's an argument that we waived that because we didn't raise that in the trial court. I'm not going to spend a lot of time. I could talk all day about whether we waived that claim or not, but I don't think it's necessary for the court, other than to appreciate sort of the lack of proof overall of the plaintiff's claim. I don't think it's necessary for the court to rule based on the lack of consideration. I think there are two issues that cry out, though, for reversal of the summary judgment on the $8,000 payment claim. The first is that what the estate proved was what it could find records of. It didn't prove what payments were or were not made, and this was pointed out in the trial court in Mr. Howerton's response to the motion for summary judgment. It's in the record, volume 2, pages 260 and 261. And that's especially important because these payments were to be made over 96 months, and it was 99 months later when Mr. Pirtle died. The fact that there was never a dispute between Mr. Pirtle and Mr. Howerton about these payments, there's nothing in the record to suggest that over that entire 96 months there was ever a dispute about Mr. Howerton allegedly not making a payment that was owed. That permits at least a reasonable inference that Mr. Howerton was making payments to Mr. Pirtle's satisfaction over the 96-month life of this agreement. And that reasonable inference is enough, we believe, for this court, applying the same standards that the trial court was to apply, to reverse the summary judgment on the claim. But there's a more compelling reason, and that is the $40,000 payment that it's undisputed that Mr. Howerton made in January of 2020. The estate acknowledged that payment in the record. The estate filed a declaration. Jack Pirtle, the administrator of the estate, filed a declaration where he said he wasn't sure what that payment was for, so in his calculation of what was owed, he just credited that to the total of what the $8,000 payments would have been. Mr. Howerton, in response, filed his own declaration. It's in the record, volume 2, page 278. And he attested that the $40,000 payment, and this is a quote, was intended to be in full satisfaction of all debts. Now, the estate argues in its brief.
There's no indication on the check to support that.
There's no indication on the check one way or the other.
There's no other paper writing to support that.
That's right.
Okay.
That's right. But again, we're responding to a motion for summary judgment, the plaintiff's motion, where the plaintiff bears the burden of basically establishing his entitlement to a directed verdict in order to prevail on summary judgment where he's got the burden of proof. So Mr. Howerton said it was intended to be in full satisfaction of all debts. He didn't say that he intended it to be in full satisfaction of all debts. He said it was intended to be in full satisfaction of all debts. That has to be viewed, that assertion has to be viewed in the light most favorable to Mr. Howerton under the summary judgment standards.
Did Mr. Howerton ever explain what debts he was talking about, what specific debts he was talking about?
He did not.
Okay. Was he ever asked that question?
Not that I'm aware of, Your Honor. I don't recall that from the record. I don't recall anything in the record where he was asked that specific question.
Okay.
But he said in full satisfaction of all debts. It's also reasonable to infer that the parties intended it to be in full satisfaction of all debts, as Mr. Howerton said, because two reasons. Number one, the checks that the estate relies on for proof of its claim, the number of $8,000 payments it found, all predated this $40,000 payment. There are no more of those $8,000 payments after this $40,000 payment. And the $40,000 payment was made almost 3 years before Mr. Pirtle died. Almost, well, 3 years roughly, 2.5 years before the 96 months of the contract expired. So, so if the $40,000 payment wasn't in settlement of all debts, in satisfaction of all debts, one would think there would be some evidence of some claim by Mr. Pirtle that you still owe me some money after that $40,000 payment was made. There's no evidence in the record of any such claim ever having been made while Mr. Pirtle was alive until October of 2022. So respectfully, drawing all reasonable inferences in Mr. Howerton's favor, as the court is bound to do in the posture we're in, the evidence of the intent of that $40,000 payment precludes summary judgment and requires reversal of the trial court's grant of summary judgment on the $8,000 payment. Now, I'd like to shift gears very quickly to the attorney's fee issue. That's the other issue on our appeal. Of course, if you reverse the grant of summary judgment on the $8,000 payment claim, then there's no basis for an award of attorney's fees anyway, because there's no claim that the plaintiff has prevailed on at that point. But even if you affirm summary judgment on the $8,000 payments, the fee judgment was flawed. The intent to depart from the American rule where everybody pays their own attorney's fees must be clear and unequivocal. A hold harmless and indemnity provision, which is, our Tennessee Supreme Court has explained just 7 years ago, that in the individual health care specialists case, they explain that hold harmless and indemnity provisions are intended to guard against claims by third parties. And that's what this one is. If you read this one, it's intended to guard against claims by third parties. It is not a clear and unequivocal expression of intent to allow for attorney's fees in the case of a breach claim between the parties. In fact, the word breach of contract, the term breach of contract or breach of this agreement, those words don't appear anywhere in this hold harmless and indemnity provision. So we respectfully submit that on both these issues, the trial court's decision should be reversed and the case should be remanded for a trial on the merits of the $8,000 claim.
Before you rest, I want to ask the question. The first contract has 3 parties, Mr. Howerton, the buyer, Mr. Pirtle, the seller, and the entity, the dealership.
Right.
The dealership is only a party for the purpose of consenting to Mr. Pirtle selling the stock to Mr. Howerton. Is that correct?
That's correct, the stock transfer.
Then how do we get to the second and third agreement? Because the first agreement simply says Mr. Pirtle's going to sell the stock for $1 million. But and maybe it's the consideration, but what supports the second and third agreement?
Well, Your Honor, I don't think we made, that's the consideration argument that I kind of glossed over because I didn't want to
get ask Mr. Sanders
hung up on waiver, but I mean, that's a fundamental issue. There is no consideration.
They're not selling more shares.
No, they're not selling more shares.
Not another dealership.
The dealership and the corporation doesn't acquire anything in any of these agreements. There's no consideration to the dealership for anything, and there's no additional consideration to Mr. Howerton in the addendum. There's the original consideration, which is the sale of the 490 shares, but the addendum should be supported by additional consideration under the law, and there's no evidence of any additional consideration, and none recited in the addendum.
All right, thank you, sir. We'll hear from you again on rebuttal. Mr. Sanders, good morning.
Good morning, Your Honors. I can start with the consideration argument since that was the last question asked, if that's okay with Your Honors. First of all, this issue was waived, and it's important here because when you have defendants admitting that they've signed a contract, to exactly what the contract says and admitting in their answer to the complaint that they owe the debts, then there's no reason for the other side or the trial court to go any further and try to develop a broader record to prove exactly why those things are true. This is the purpose of an answer. And so when we moved for summary judgment, we moved almost exclusively based on the four corners of the documents and their admissions as to the fact that these were binding, that they had performed under all of them, and that they had gotten exactly what they received. So the trial court was not presented with these arguments, and here on appeal, they're presenting issues that we didn't have occasion to respond to and further develop a record on in the trial court. But there is still proof of consideration. And you can see how this plays out. We haven't cited to it in the brief, but I'll do it here. In the record at pages 339 to 341, Mr. Howerton was asked about how this progressed, because we couldn't tell after the fact, except through Mr. Howerton, exactly how they had ended up with three separate parts of the same agreement. And I'll remind the court that in the answer to the complaint, they admitted that these were all part of the same agreement, and that all of them were executed before anyone performed under any one of the parts. So you can see what happens in Mr. Howerton's testimony and in the sequence of the documents. You have an initial discussion with a document that was partly drafted by a lawyer. On the same day, they expand the discussion beyond just the transfer of shares. This is the July 2nd handwritten note, where there is a document providing for a unilateral benefit to Mr. Howerton, which is a release of over $1 million in prior dealership debts. So they're not just talking about the shares on this first day when they hadn't set a date for performance or any other terms for performance. There's missing information in the original document. They then sign this second document, which is ironic, considering their arguments on consideration here. That document is not supported by consideration, but they absolutely received the benefit of having Mr. Pirtle, the decedent, assume responsibility for all these past dealership debts while they continued to try to pay off the dealership. And so you have the three parts. Then the other part is Howerton and the dealership assume responsibility for these $8,000 payments for 96 months, and then they make the vehicle payments for 96 months each. And all of that was admitted in the answer to the complaint. So the consideration is multifaceted, and you have to look at all three documents in order to see what the consideration was. In this context, Mr. Howerton became the sole operator and sole owner of a company that operates under Honda, but it's his to deal with, his to benefit from it. So in deciding whether it's worth it for the corporation to sign on to this, Mr. Howerton's acting not just for himself, but an entity that he wholly controls. And so the fact of the change of ownership is itself consideration. When a corporation acts to choose its leadership, that is itself an action that benefits the corporation, at least in its view. That's what happened here. The court also can't forget that the fact that the corporation's included as a co-signer is no different than if a bank allows a father to co-sign for his daughter on a car purchase. People co-sign on documents all the time, and in this case, Mr. Howerton co-signed with an asset that he was to become the sole owner of. So this was consideration to the decedent as well, that this asset, that this company would also be responsible for the debt. And so we don't have a full record on all of that, but you have more than enough here to support the trial court's conclusion where there was no contest. We specifically argued that the agreement was valid and enforceable at summary judgment, and you can see their response. Their response is a few pages long. They cite the legal standard, and they raise a grand total of one argument, which is that there were conflicting facts in the record. This $40,000 payment was put in through a declaration from Mr. Howerton, this reference to it being intended to be in full satisfaction. Your Honors, that was a throwaway issue. It's not even mentioned in their actual response to the summary judgment. It was just in a declaration where they kind of had this add-on, and it was easily disposed of. And the reason is that Mr. Howerton only spoke to his intent. He couldn't have possibly had personal knowledge of the intent of the decedent, and if he had tried to say that both myself and the decedent intended for this to be in full satisfaction, we would have raised the dead man statute as an objection. We didn't, because it didn't say that. And Your Honor asked an excellent question about whether there's anything in the record about the $40,000 payment. The reason this didn't go anywhere, and the reason that counsel didn't make much of an argument at summary judgment on this, is because Mr. Howerton had said less than 3 months before they filed this declaration that he had no idea what the purpose of the $40,000 payment was. That's in the record on page 478 in his deposition. He was asked, what was the purpose of this? He said, I think it was probably for a car payment. I think he wanted me to pay off a car. Or it might have been to reimburse him for something. I don't know, I can look. And then 3 months later, we get a declaration saying it's intended to be in full satisfaction of the debt. So when you ask what debt it was, I'm not gonna stand here and accuse Mr. Howerton of lying. He doesn't say which debt, and I think that was a very clever omission by Mr. Howerton. He doesn't say which debt because he had already said in his deposition 3 months earlier that it was intended to pay off something, but not the entire debt that's at issue in this case. So this $40,000, there's no meeting of the minds, and I'll remind the court also, Section 5 of the contract says very specifically, any modification to the obligations in this agreement have to be in writing and signed by the parties. So not only do we not have a check saying that it's in full and final satisfaction of the debt, or a note in the file, or anything indicating that Mr. Pirtle, the decedent, had any idea that this was Mr. Howerton's intent, he didn't sign off on it. He didn't accept it, as full and final payment. There's no indication that happened. So this is a complete non-issue, this $40,000 check. If you go to the other argument, which is this handwritten note, there are 4 or 5 reasons why this is a non-issue, and this is the only substantive issue they raised in the appeal. This does not present a factual question. This is a question of legal interpretation for the court. What does the contract say? We agree with what the note says. It is also undisputed that the reference to the past dealership debts on this single-page document is a reference to the prior debts, and you can look at the transcript that I referenced earlier where Mr. Howard.
The Shelbyville dealership?
Yes, he owed over $1 million along with Mr. Pirtle, and this was a reference to that. So for them to take a handwritten note in the corner of that document and say that the reference to debts meant anything other than the debts very specifically referred to in the top of the document on the same exact page is contrary to the rules of construction. But even if you could assume that this was meant to cover an addendum that had not yet been drafted and signed, which occurred within a few days of this, even if you could assume that, the release of debts had 2 conditions in it. One, they had to satisfy all of the payment for the full dealership. So when they added an addendum that Mr. Howerton signed and performed under that says that you're going to pay for the dealership in full, he had to actually pay off all of that as further payment for the shares in order to invoke a release. If you then look at the other part of it, they had to honor all agreements for 1 year. We know that they were delinquent on both the vehicle payments provision and the $8,000 provision by February 2017. So all of these amounts were due and owing, and what they're basically asking this court and what they asked the trial court to do is to say, well, there weren't any additional payments to be made during this 1 year because they were already past due, and we're fine to just wait the year out and then they're all released without us doing anything. Honoring an agreement means paying the amounts that are actually owed. They didn't do that, and they were demanded by the time that 1 year had passed because the decedent's estate, Mr. Pirtle, as the representative, asked them to do that. So they didn't pay it. They said instead, no, we were absolved. If you look at our amended complaint, Mr. Howerton's story has changed 5 times during this case. They're just finding a reason to try to avoid paying this money. The first argument was that there was some kind of verbal agreement that he'd made where he didn't have to pay anything else. The second agreement was that he was absolved, or the second argument was that he was absolved by this 1 year provision. And then it was the $40,000 payment that he hadn't remembered when he answered the complaint. He didn't remember it in his deposition, and then he puts this vague reference to paying off the debt in his declaration in response to summary judgment. None of that is credible, and it really is all irrelevant when, in the answer to the complaint, they admitted every single fact that the trial court needed. They've made this argument about, we didn't produce enough proof to shift the burden to them to respond. They are asking this court to credit arguments that they had every reason to raise at summary judgment. Rule 56, the Supreme Court's opinion in Rye, and however many other cases since then, have all said that the defendants, once they're on notice of these issues and there's sufficient proof in the record, which we relied on their own admissions, they have to come forward with proof and respond. Everything that they have raised in this appeal that wasn't raised at summary judgment, including the argument on attorney's fees, is waived. And with regard to the attorney's fees issue, they did not mention that in their response. At the hearing, it was a non-issue. The hearing transcript's not in the record, but it was essentially not a discussion because there wasn't really any discussion about it. And that is why when we get to this motion to alter or amend that turns into a Rule 54 motion, as it should have, they file a memorandum 4 months after summary judgment. And when the trial court sees that motion where they essentially try to redo the whole thing after doing, after changing course and realizing, okay, this money's owed, I don't know what the strategy was in the first instance. I think they told the truth at summary judgment on every fact that they admitted. I don't think there's a question about any of it. And, they want to call into question, the number of payments made, and I'll get to that in a minute, but there's no contradicting proof on any of these. They're just asking the court to infer things where Mr. Howerton has never actually contested them. And so on the attorney's fees issue, when the trial court gets a motion under Rule 54 or Rule 59, and the Court of Appeals has said that this, you're supposed to look at those similarly. It's not the same exact standard, but you can look to Rule 59 for guidance as to how you look at a motion to revise under Rule 54. The trial court had the discretion to decide whether or not, having failed to raise the arguments they needed to raise at summary judgment, the defendant should get a second bite at the apple. And that transcript is in the record, I believe. The order's definitely in the record. And the trial court disposes of this in one sentence. I'm not going to revisit this. I'm not going to revise my motion or revise my order, and the summary judgment order stands. There's no substantive discussion. So when we get to this issue of attorney's fees, they're asking the court to look at this de novo. But the fact is the argument wasn't preserved at summary judgment, and the trial court exercised its discretion not to let the defendants try to redo it, 8 months later when we finally got to this hearing. He then promptly denied request for a permissive appeal. So when you look at the Rule 54 motion, that is the only place where this issue is in the record, and that is reviewed for an abuse of discretion. If they don't preserve it at summary judgment, it's already off the table, unless the trial court sees fit to say, okay, well, there's something new here, there's a basis, whatever the trial court believes is appropriate to say that, this is something that we can look at again or that I should look at again. The trial court didn't make that decision. If the trial court had revised its order on the grant of summary judgment with respect to attorney fees, it would have created an issue where you could look at the substance and then it would be either reviewed de novo or as you review the facts de novo. It didn't do that. So this is the discretionary decision not to revisit, which means that this issue is reviewed on abuse of discretion. It's not before the court. But on the substance, I'll just say that this is a broader provision. If you compare it with the two cases that they're relying on, one is the Holcomb case, the other is the individual healthcare specialist case. The Holcomb case, it is much narrower. It talks about loss or damage arising from the failure to comply with the contract. I don't think there's a reference to attorney's fees specifically in the way there is here. The individual healthcare specialist case talks about any action or lack of action by the other party associated with the agreement in the context of two insurance companies doing business. They're clearly referring to third-party claims and the consequences that might flow from their decisions under these contracts. This contract's different. It talks about any and all loss and damage arise by reason of any claim, debt, liability, or obligation of the buyer or the corporation. So they couldn't have been any broader, and it references the availability of attorney's fees twice in the same provision. So on the merits, I submit that more than covers the award of attorney's fees here. We've also appealed, and I've got about a minute. There are two errors that I'll let my brief speak for, since I don't really have time to go through it here. The trial court presumed that even though they had breached this contract, that our client was not allowed to seek full damages on the whole deal. And that really goes to what counsel argued today. They're acting as if, the statute of limitation doesn't exist. This wasn't required to be brought within the 96 months. They had 6 years from the dates of performance to sue. There is no statute of limitation defense that's been raised in this case. So the idea that everything had to be contested and that our client had to say something within 96 months or he waived his rights or that the decedent is not correct.
Do you have any proof of damages?
The proof of damages is that this contract liquidated damages became available under binding Tennessee law the minute that they breached the contract. Our client, the decedent, were both entitled to call this contract and seek liquidated damages prospectively, and we've cited extensive case law on that. They haven't even responded to it in their reply brief.
So you're arguing that even though you can't show that your client incurred a car rental or car lease expense, you're entitled to a judgment against Mr. Howerton for that amount.
For the remaining payments, and that is because Mr. Howerton admitted in his answer to the complaint, he admitted in his deposition, and he admitted at summary judgment, or didn't contest at summary judgment, that under the vehicle payments provision, they owed a total of 192 payments. And it is why he made more than 96 payments. I mean,
But that's 96 times 2. That's not, you can't stretch it out for 16 years. It's 8 years.
If there would have been a statute of
It's
limitation.
2 cars for each for 8 years.
It doesn't specify that, and actually,
Well,
if you
it's obvious.
if you look at the course of conduct of the party, he was making one payment most of the time, and then he continued to make payments beyond 96 months and beyond 96 payments precisely because he understood that he owed 192, and that's what they admitted, and that was the theory behind it. And so when he stopped paying under the main part of the contract, $8,000 a month, in February 2017, he was already in breach, and he didn't have a right to enforce that provision. And so, yes, there would have been a time when the claim expired because they would have had to have brought each one of these within 6 years of the statute of limitations. But in this case, our client was entitled to seek, the decedent would have been entitled to seek liquidated damages for the reasonable value of whatever remained of 192 payments. The fact that he continued
But is he in breach if there isn't a car being leased?
he was under breach.
You don't have any proof that there was a car being leased by either Mr. Pirtle or his wife.
This is the issue that we address in the brief more fully, but basically when you breach part of a contract, you don't get to keep performing under the other part.
That's true, but you don't get damages when you can't prove anything.
The damages was that he was entitled to 192 payments. That's our argument.
Well,
Your Honor.
I totally disagree, but we'll.
I understand, Your Honor.
We'll consider that. Thank you.
Thank you, Your Honor.
All right. Mr. Colbert, forgive me. By the way, I'm sorry that CBS has canceled your contract.
Thank you. You know, I like Stephen Colbert, but I think that pronunciation is just a little
Stretch.
Just,
Okay. Maybe if you wore a tam or French beret,
Maybe.
I should say beret.
maybe. You know, Justice Kirby referred to me as Colbert
Well, she's right. So.
recently. She's always right. So
Supreme
yeah,
Court.
she's always, at least for a few more months. So, Your Honor, I just need to refer back quickly to the declaration of Mr. Howerton again and the $40,000 payment. He recites in his declaration the additional $40,000 payment made to Mark Pirtle was intended to be in full satisfaction of all debts. We're here on a motion for summary judgment by the plaintiff. We are entitled, as the respondent to that motion, to the
But
benefit of all.
Did he earlier say he didn't know what the $40,000 payment was for?
He said he didn't know and he would have to check. And 3 months later, he filed this declaration with an explanation of what it was for.
All right, thank you.
And that's got to be construed in the light most favorable, and whatever reasonable inferences can be drawn for it have to be drawn in Mr. Howerton's favor. As far as the argument that the contract required that amendments be in writing, this court's decision in Lancaster versus Farrell Paving, it's at 397 Southwest 3rd, 606. I think that disposes of that issue. There, this court said that a contract, even if it says that amendments can only be in writing, it can still be orally modified. And an amendment may be implied from the course of conduct of the parties, even if the contract says amendments are supposed to be in writing. We believe the course of conduct of the parties here is sufficient, at least for purposes of responding to a motion for summary judgment, to establish that the parties intended, as Mr. Howerton said, namely that the $40,000 would be in satisfaction of all debts, because this was not a statute of limitations argument. It's a factual argument that there's no evidence of any claim at any time during the nearly 3 years after this $40,000 payment was made that anything else was owed. And that course of conduct helps to substantiate, we believe, the inference we're asking the court to draw, and substantiates justification for treating Mr. Howerton's statement as true. As to the fee claim and this whole argument about Rule 54, it was the trial court that had discretion under Rule 54.02 to decide whether he was going to allow this additional argument. And there's a case, Harris versus Churn, a Tennessee Supreme Court case, that says the court has discretion about considering new matters on a motion to revise. There's nothing in the record, there's nothing in the trial court's order to suggest that the court refused to consider any issue about the attorney's fee claim because it was raised in a Rule 54.02 motion. That was what the trial court had discretion. And if this court is going to consider anything in that regard, you would have to decide whether the trial court abused its discretion in entertaining that argument about the fee claim, because there's nothing in the record to suggest that the trial court rejected it because of when it was raised. And finally, I just want to remind the court once again of the posture this case is in. It was a motion for summary judgment by the plaintiff. This $8,000 claim, it should have been tried on the merits. There was enough in the record to justify taking this claim to trial on the merits and not deciding it on summary judgment.
All right. Thank you, Mr. Colbert and Mr. Sanders, for your arguments. We'll take this matter under advisement. Call the next case, please.
In re Kansas v. et al.